In the second edition of the book titled The Cycle of Juvenile Justice, the late Thomas J. Bernard and Megan Kurlichek assert that there is a cyclical pattern in juvenile justice where the same sequence of policies has been repeated over 3 times in the last 200 years. In fact, the authors argue that future policy changes regarding juvenile justice can actually be predicted by closely examining this cycle. The authors also argue that the behaviors that we describe as juvenile delinquency today first appeared in the United States and Western Europe around 1800 and persist to this day. They attribute juvenile delinquency to urbanization, industrialization, and the breakdown of traditional social controls. The authors contend that since 1800, there are numerous aspects of juvenile delinquency which have stayed the same. For example, they assert that young males have always committed more crime than members of other groups. While the overall incidence and rate of crime may change, what remains constant is that young people, especially young males, are disproportionately involved in crime. In their book, Bernard and Kurlichek also point out that there are special laws only juveniles are required to obey. These laws are typically referred to as status offenses. Status offenses have been around for over 200 years. Examples of status offenses, according to the authors, include truancy, running away from one's parents, underage drinking, and refusing to obey one's parents. The authors contend that juveniles are still required to obey special laws, even in those states which have decriminalized status offenses. They assert that status offenders may be redefined as criminal offenders so that they might be processed through the juvenile courts. The authors argue that there have been separate laws for juveniles for centuries, and attempts to change these laws have only resulted in new laws or new approaches to control certain types of behaviors in juveniles. Bernard and Kurlichek also maintain that for the last 200 years, juveniles, for the most part, are often punished less severely than adults. They trace this back to the Code of Hammurabi, which was written over 4,000 years ago. Here, juveniles were treated more leniently than adults. Also, they examine Roman law with the 12 tables, where there was absolute immunity from punishment for children below a certain age. Today, according to the authors, in most states within the U.S., young offenders below the age of 18 are sent to the juvenile court. Nevertheless, there are states which have lowered the maximum age for juvenile court jurisdiction. For example, in New York and in North Carolina, if a juvenile is over 15 years old, he or she will be tried in an adult court. Also, it is important to point out that even if a juvenile commits a crime, if the offense is serious enough, or if he or she has committed multiple offenses, the juvenile can be waived to an adult court. And in some states, certain offenses which are very serious, such as murder, may automatically be waived to an adult court. In these cases, the defense attorney will then try to get the case transferred back to the juvenile court. There are also other aspects of juvenile delinquency which have remained unchanged for the last 200 years. The authors assert that older people tend to believe that the current group of young people commit more frequent and more serious crimes than juveniles in the past. They refer to this phenomenon as the myth of the good old days. The authors assert that whether juvenile crime is high or low, many people tend to believe that it is worse than before. Therefore, people always tend to believe that we are right in the middle of or on the verge of a juvenile crime wave, regardless of what the actual reality might be. Bernard and Kurlichek also argue that many people blame juvenile justice policies for the supposed juvenile crime wave as either being too lenient or too harsh. This explains both the creation of the first juvenile institution as well as the development of the juvenile justice system. For example, prior to 1825, there was no juvenile institution. Instead, there were only adult facilities to send juvenile offenders to. So naturally, judges, juries, and prosecutors wanted to avoid sending juvenile offenders to adult institutions. As a result, many juveniles got off scot-free. People were very critical of this, which eventually led to the creation of the first juvenile institution in New York City in 1825. The first juvenile court in Chicago also emerged in a very similar manner. It was established in 1899 because the adult courts were believed to be too lenient with juveniles. As a result of the creation of the juvenile court system, more youths were subjected to the control and supervision of the adult court system. It is worth mentioning again that the authors attribute juvenile delinquency to the transition from agricultural societies to modern industrial societies. In the United States and in Western Europe, the transition occurred at about the same time in the early 1800s. Interestingly, when other nations made a similar transition, juvenile delinquency also occurred. For example, as countries in Africa, Asia, and Latin America underwent modernization during the latter part of the 20th century, they too confronted the problem of juvenile delinquency. Again, this is a phenomenon which no country really experienced as a traditional agricultural society. Population growth coupled with urbanization put juvenile offenders into close contact with potential victims, and immigration created culture conflicts which also led to crime. And industrialization increased the number of movable goods, which led to a significant spike in property crimes. In the United States, the juvenile justice system was created to capture young, underprivileged people and shape and mold these individuals into productive people so that they would not steal the property from the wealthy members of society. The authors argue that universities and colleges were used to mold young people from the middle and upper class segments of society, while the juvenile justice system, on the other hand, was used to mold young people from the lower classes who were deemed to be the most dangerous. The first juvenile institution was created in 1825 in New York by powerful Protestant middle-aged men who had grown up in quiet and orderly small towns. As America made its transformation from a rural to an urban society, these men believed that young immigrant youths were creating havoc in the cities. When youths were caught committing crimes, they also noticed that judges and juries often refused to convict them, and it would entail sending a young person to the penitentiary. So as a result, youthful offenders often got off scot-free. These wealthy Protestant men decided to build a juvenile institution which was focused on reform rather than punishment. When this facility was built, it even took in juveniles who had not yet committed any crime. Most of these juveniles were committed to this House of Refuge until they were 21 years of age. Again, virtually all of the juveniles who resided within this institution were immigrants. The children of Irish Catholics soon came to dominate the population inside the House of Refuge. Eventually, there was no more room inside this institution, so youths were sent to work on farms in the newly settled states such as Ohio, Indiana, and Illinois. These young immigrants were essentially indentured servants until they turned 21. They were taken from their families and either confined in a facility or placed in homes which were hundreds of miles away, and they were made to work for their keep. The natural parents of these youths were not typically told of their children's whereabouts. In their book, Bernard and Kurlichek point to an 1838 Pennsylvania Supreme Court case, which they refer to as the case of Mary Ann Krause. In this case, a girl was sent to a Philadelphia House of Refuge even though she had not committed a crime. Her father argued that the state had no right to confine his daughter. However, the Pennsylvania Supreme Court rejected the father's arguments and ruled that it was legal to help Mary Ann because of the state's role as parens patria. This is a Latin phrase which means parent of the country. The court held that the state had an obligation to take over as this child's parent, and because she was not being punished, this child was not entitled to any due process protections. This case essentially affirmed that children could be held in houses of refuge until their 21st birthday, even if they had not committed an actual crime. In 1868, 30 years later, the Illinois State Supreme Court ruled that a young juvenile who had committed no crime could not be held in a reform school. The court concluded that the juvenile, whose name was David O'Connell, was being punished rather than helped. The court held that it was illegal to send poor children to reform schools unless they had committed a felony offense. It was not long after this decision that reformers went looking for a new basis to control poor immigrant children. Reformers always sought to expand state power rather than limit it. So after the O'Connell decisions declared that it was illegal to confine juveniles who had not committed a crime in houses of refuge, social reformers created the first juvenile court. The juvenile court, which had civil rather than criminal jurisdiction, would be used as a tool to control children who were deemed to be among the dangerous class that threatened the status quo. Bernard and Kurlichek argue that while the first juvenile institution had been founded by men, the first juvenile court was largely the result of the work of women. These women were the wives and daughters of prominent Chicago politicians and businessmen. These women went to the city council and state legislatures and lobbied for major policy changes in the handling of juveniles. After the O'Connell decision, these reformers wanted to find a way to control poor immigrant juveniles, even those who had not yet committed a crime. And these reformers were able to accomplish their objective by removing children from the jurisdiction of the adult criminal court and establishing a juvenile court which was not criminal in nature. Rather, the juvenile court was a social welfare agency, and children who had needs of any kind could be brought into the juvenile court. After the first juvenile court was established, the law provided court workers with virtually unlimited power over poor children. And because the juvenile court was a civil court rather than a criminal one, young people brought within its jurisdiction did not enjoy due process protections. The juvenile court returned to handling juvenile offenders as it had handled them before the O'Connell decision. It established a new basis for the old practice of sending poor children to rural institutions for their own good, even if these children had not committed an actual crime. As long as the caseworker thought it was in the best interests of the child, it was once again no longer necessary for that child to have committed an actual criminal offense. The few due process safeguards that had been provided to juveniles under the O'Connell decision were wiped out by the establishment of the new juvenile court. This pattern would go uncontested for the next 70 years. It was not until the mid-1960s that the U.S. Supreme Court would make key rulings which would provide juveniles with important due process safeguards.